Thank you very much. Ladies and gentlemen, I would like to express my gratitude to the organizers for the magnificent event and for the topic on the conference, which is very interesting and very inspiring because of the Central Europe point of view. And being the last speaker on the last panel, I would like to express my gratitude to the audience. You are still here, and I think that we all share this gratitude. The topic of my presentation is the right to private life under the European Convention, and first of all, we need to underline that the right to privacy is deeply embedded with the fabric of our democratic society. So it encompasses the notion of personal autonomy, the ability to control personal information, and freedom that we have from unwanted inclusion into our private lives. As the drafters of the European Convention of the Human Rights articulate in the Article 8, it is also important for the safeguards of our individual dignity and our autonomy, especially in the time of modern challenges. Through its existence, the European Court of Human Rights has played a prior role in the interpreting and applying the right to privacy under the Convention. And in my presentation, I would like to go through, very briefly, through works of the drafters, a little bit of doctrine opinions, and mostly the practice of the European Court of Human Rights concerning the right to privacy, examining some cases and some cases that came from the countries from Central Europe. And I try to explore some dynamic nature of the privacy rights and considering how the European Court interprets and how it is adapted to the new challenges that we need to that we do have in modern time. As you are all aware of the fact, the right to privacy is included in the Article 8 of the European Convention, and we have four interests identified in this article. So we have namely private life, family life, home, and correspondence. And of course, I will focus on the family life, private life, but it is important to be aware of the fact that in many cases, these laws overlap. So when we do have the case, in many situations, there is a life, the need to protection the life to privacy, and also the protection of the family life, the privacy, and the correspondence, and so on. As it comes from the travaux préparatoires to the convention, the Article 8 of the European Convention is inspired by the Article 12 of the Universal Declaration of Human Rights, and it was clearly underlined in the text of the Travaux Préparatoires, and the inspiration from the Universal Declaration was the element that was one of the most important. At the beginning, the text of the article mostly focused on the freedom of arbitrary interference. Then there was a British proposal which underlined that every shall have the right to freedom from governmental interference with his privacy, family, house, or correspondence. So we have a very limited look at this right because it protected only from the governmental interference, but not from the situations that our private life will be might be violated by the other members of the society. Fortunately, the Conference of Senior Officials proposed that everyone's rights to private life, family life, home as correspondence should be respected, and the final version prepared by the Committee of Ministers was voted by the Consultative Assembly, as we have now in the Convention. When we look at the understanding of the right to privacy, we need to be aware of the fact that the court never gave the clear definition of private life. For Strasbourg judges, the notion of private life is broad and cannot be defined in any way exhausting. That comes from the Costello-Roberts against United Kingdom case. In some analyzing of the right to privacy, we can find that the Commission practice concerning the meaning of private life has never been distinguished, neither by its clarity or its discipline or some other professors underlined that some decision as to interpretation or agreed definition are however general, and they need to be clarified by existing in case law. So mostly the case law is the element that gives us the information how we should understand the private life. And of course, in last years, the court tried to give us some answer, tried to create a kind of conceptualization of the private life. And when you go to the jurisprudence of the European Court of Human Rights, first we need to find that the court determines wherever the applicant claims within the scope of the Article 8. Next, the court needs to examine wherever there has been an interference with the right of wherever the state positive obligation to protect the right have been engaged. And of course, there are some conditions that in the situations when the state may interfere with the enjoyment of a protection of rights, which are set in the paragraph 2 of the Article 8. And we have here the interest of the national security, public safety, the economic well-being of the country, the prevention of disorder or crimes, and the protection of health and morals, and the protection of the rights and freedoms of others. So this is our limitation. And the first step is the three tests using in many cases, in many articles and rights protected by the convention. So it is necessary to ask if there was the legitimate aim. If the restriction purposes a legitimate aim that comes from the paragraph 2 of the Article 8. If there is a proportionality, and if the regulations were necessary in the, or behavior that were necessary in the democratic society. And this gives us quite wide understanding of right to privacy. And in a number of cases that I will not be able to examine it very deeply, but just show, we can find that the right to privacy includes someone wishes. It's also the right to establish and develop relations with other human beings, especially in the emotional field. It also includes activities of business and professional nature, so it's not just dedicated to the close relations with people, but also those ones which are the professional relations. Private life also embraces aspects of individual physical and society identity, especially like gender identification, name, sexual orientation, and sexual life. It also protects a right to personal development and the right to establish and development relations with other human beings. And of course, we can find another aspect, which is the right that the right to privacy covers the physical and psychological integrity of the person, and also some aspect of the social identity. And in those landmark judgments, some standards, some basic standards were created, but as it comes from the date that the judgments were delivered. The first was in 1978 and the last one in 2020. We are able to find that there were some new challenges. At the beginning, the main challenges were focus of the safeguards of secret surveillance and some operation of the secret services, and the last are connected with, for example, like the case against Romania, the privacy in workplace and the private of the correspondence that the employer had during this working hours. And when we look at the right to privacy from the point of view of Central Europe, I decided to put some three fields of the understanding of the right to privacy. That is how the European Court divides those three fields. And I try to connect it with some cases. The first category is the physical, psychological, and moral integrity of individuals. And in such cases, we have mostly aspects like domestic violence, like choosing the medical treatment, a very famous case against United Kingdom, treaty against United Kingdom dedicated to the assisted suicide problem, and the right to reproductive choice, and also choose to circumstances to becoming a parent, becoming a genetic parent, the access to in vitro fertilization, and the protection of individuals' well-being. The second part is the private life as protected in the private life protected is privacy. So this is the very traditional aspect of the right to private life. So it protects people's interests not to being exposed to unwanted attention from state or from the other people. And in this situation, we have the examinations dedicated, for example, to one's honor or reputation. The honor and reputation are included in the Article 12 of the Universal Declaration of Human Rights, but the drafters of the European Convention decided not to include it in the text of the Article 8, but the juridical practice of the European Court shows that the honor and reputation are also considering as a part of the right to privacy. And the last, and here we also have the protection of personal reputations and all the cases that are connected with the restrictions concerning police surveillance, registration in the police databases, and tracking of individual movements, and surveillance of communication. And the third category concerns the protection of personal autonomy and identity. And here is the aspect right to personal development and right to establish relations with other beings. And the cases that court examined are connected with the personal choice to individual desire appearance, for example, choosing the haircut, wearing a beard, or wearing religious clothes. We have also here the gender identification, the ethnic identification, name, and sexual orientation, and also sexual life. And as I see, I have 5 minutes. So I wanted to examine those cases and give you some examples from those cases why they are so important in these three fields of category, but I think that needs to be included in the written version of my speech. Just two elements I would like to add. The first is the case that was already mentioned today, so Wawrzyczka and others against the Czech Republic. it was an important case also from the point of view from Central Europe, because the problem of the obligation to vaccine was something that was increasing in many countries, and this case included the intervention of Polish government and Slovak government also. And it shows that the problem is not typical just for the Czech Republic, but also typical for the other countries that were interested that the court delivered a proper or accurate judgment for the situation. And as the right to privacy, I just focus on one element from Solska and Rybicka case, because it's one of the cases in which the European Court of Human Rights were not able to split right to privacy and right to family life. When you will look at this judgment, you will not find any line or any one expression of the European Court of Human Rights that's separating these two rights. They are always goes together, and which is very important for me, because from my previous research it was quite interesting. Every time when the court recovers some cases connected with the death of the person who was relative, the privacy and the family life goes together. Because in this case, the Płocki against Poland, and Panulo and Forte against Italy, and Henri Vionnet against France, and Petrova against Latvia, and Elbert against Latvia, all the cases connected with the death of the close relatives, and always privacy and family life goes together. And because I would like to have some conclusions, the first element is that during its history of the jurisprudence, the European Court of Human Rights established several key principles that are dedicated to the right to privacy. So, privacy as a fundamental right. So the right that covers or reflects the relations to other right, and I mean that the right to privacy goes always with some other rights, with the right to family, the correspondence, the right to home, but also very often it goes with the Article 13, so the discrimination. Another aspect, another key principle is the broad scope of privacy. The interpretation of the right to privacy evolve during the years, and joining to the Council of Europe and being under the jurisdiction of the European Court of Human Rights by Central and Eastern countries give a new impulse, give a new view how the right to privacy should be understood. We have a lot of positive obligations that were developed by the European Court of Human Rights, especially when we are talking about the new technologies and the obligations of the state to fulfill the safeguarding of the public, of the private law, but also the margin of appreciation, which is especially important for the Central and Eastern countries because of their specific experience of non-democratic regimes and the interpretation of the right to privacy in this context. And for the future, I identify three important aspects that the jurisprudence will develop, in my opinion. The first is the issue of privacy versus the action of the state security organs. This is especially important nowadays when we have quite difficult political situations. The second issue is to identity of the reproductive rights, because the expansion and the extension of accessibility to assisted procreation method is increasing. This is typical for the Western countries because the society were in better financial condition, so the members of the society were able to using the the assisted procreation methods like surrogacy, like artificial insemination, like embryo adoption. But now the situation in Central European countries, from the economical point of view, is increasing. And I think that in a few years we will have similar problems. And as it was pointed out in Wedeł against France, people have the right to know their origins, that they are being deprived from their wide interpretation of scope of the notion of private life. And the third element, and the last, is that the issue of privacy in the dynamic development of the new technologies. And here are two separate problems. The first is that the law does not always goes or keep up with the dynamic of the challenges. And the second is that even if we do have safeguards, they are often quite difficult to be included in our ordinary life. Everyone who uses internet knows how it's problematic to read all these conditions for going to the website, for example. Thank you very much for your kind attention.